It's 9:03 on Wednesday, February the 18th. The House Criminal Justice Subcommittee is now in session. Members, please be sure to log in and we will take roll. All right. Madam Clerk, take the roll. Mr. Clerk, I'm sorry.
You're fine.
I'm so sorry about that.
Mr. Chairman, you have 6 members present. You have a quorum.
He's my neighbor down the hall. Thank you. We're good to go. I was just used to seeing someone else down there. I apologize about that. Members, do we have any personal orders before we begin? Representative Scarborough.
Good morning. Thank you, Chairman. I'd like to recognize our group from the UT Institute for Public Service. I think we've got some guests out in the audience. If you guys just raise your hand, let us know where you are. You guys welcome.
Thank you for that. Thank you for being with us today. Anyone else? Seeing none. Welcome back, Representative Scarborough. We have missed you and we're glad to see you. Hope everything is going well. All right. Our Sergeant of Arms, Mr. Tyler Muniz, will bring us our weekly words of wisdom.
Good morning, everyone. Before I start, I've been waiting a few weeks to make this announcement. I would like to give a shout out to the Republican Member of the Year, Chairman Doggett. Now to the words of wisdom, all the way from the North Pole. I just like to smile. Smiling's my favorite. Buddy the Elf. Y'all be like Buddy today and have a smile.
All right. Thank you, Mr. Muniz. All right. Let's dive into the calendar. A few things. Item number 2, House Bill 1679 by Chair Lady Moody will be rolled 2 weeks. Item 10, House Bill 2264 by Representative Martin will be rolled 2 weeks. Item 16, House Bill 2622 by Representative Miller will be rolled 2 weeks. And item number 3, House Bill 2064 by Chairman Todd will be rolled 2 weeks. Just for reference, if you hear us rolling things 2 weeks today, that's because we will not be meeting in this capacity next week. And so it's not that we're setting them off for 2 meetings. That's just going to be the next time that we will meet in here. So without further ado, Leader Lamberth.
Mr. Chairman, I will make just kind of a public service announcement on that. There will be budget hearings going on all next week during this time slot, and our members will be riveted to those. We would encourage all of the citizens of Tennessee to be focused in on those as well. It's your budget. It's your money. It doesn't belong to the state. And so we're going to focus on that like a laser beam next week on some of the largest departments of state government. And so that will pretty much cause conflicts for just about every other committee. And that's what we'll be doing next week. So I hope everybody tunes in. Thank you, Mr. Chairman.
Thank you for that. Item number 1, House Bill 2279 by Representative Cochran. You are recognized. There are 2 amendments. Do you wish to proceed with 1, 2, or both?
Thank you, Mr. Chairman. Yeah, let's proceed with Amendment 013441.
Amendment Code 13441. You have a motion second. You're recognized on the amendment.
Thank you, Mr. Chairman. This amendment makes the bill. And so House Bill 2279 is the Crush Transnational Repression in Tennessee Act. And so it is to deter and punish foreign directed intimidation, coercion, harassment, enforcement activity inside Tennessee carried out on behalf of a foreign adversary. And so foreign adversary, obviously that's a federally defined term, specific countries that are included in that. And so this act would enhance criminal penalties for qualifying offenses. It blocks enforcement of any type of foreign legal system that conflicts with our constitutional rights. Even including Sharia-based or other foreign law frameworks. I'll give you one quick example of a situation that this would address. At Harvard a couple years ago, there was a Chinese ambassador who came in to speak. There were students of Chinese heritage there who were protesting the current communist government in China. There were additional Chinese students who then attacked those protesters. If that were to happen, let's say at the University of Tennessee, and we were to show that the attack on those protesters was and somehow connected to China, which is a foreign adversary, there would be enhanced penalties on that assault. That's basically the crux of this bill. Mr. Chairman, I'll yield to any questions.
Thank you for the explanation. Any questions on the amendment? Seeing none, objection to the question. Seeing none, we're voting to adopt Amendment Code 13441 on House Bill 2279. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt or on your bill as amended. You've explained the bill. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 2279 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, 0 noes.
The ayes prevail. House Bill 2279 moves on to full judiciary.
Thank you, Chairman and committee.
As amended, yes. Item number 4, House Bill 1802 will be rolled to the hill. Item number 5, House Bill 2253 by Chairman Williams.
Second.
You are recognized. There are no amendments.
Thank you, Chairman and members. The House bill actually has 2 components. One was a cleanup to Jillian's Law last week. The TBI brought to me as a cleanup portion. The second portion, because of bill limit numbers, allows me to do something also in regards to felonies. And so the first part of the bill clarifies that an individual who cannot possess a firearm under Tennessee state law or a court order also cannot purchase a firearm. This addition to the law would give consistency to the law. Without this change, there is a current loophole that allows some individuals to purchase a firearm in Tennessee, but then be subject to immediate arrest for the possession of said firearm. And so that portion of the bill is what cleans it up as well. The second portion of the bill was brought to me by a detective in my district from the Cookeville Police Department, which would increase the penalties in current statutes. For instance, a person who is convicted of possessing 50 images of child rape can be charged with a Class D felony offense with a standard sentencing ranging from 2 to 4 years. To put that in perspective, a person convicted of selling a few Xanax would also have the same charge. Secondly, a person convicted of possessing 51 to 100 of the same types of images would be charged with a Class C felony with a standard sentencing range of 3 to 6 years. A person convicted of possession or of a few hydrocodone pills would also have the same penalty. And finally, a person who's convicted of possessing 101 to thousands of child rape videos can only be charged with a Class B felony with a standard sentencing range of 8 to 12 years. If you had a gram of cocaine on your possession, it would be the same 8 to 12 years. What this would do would increase those penalties to what my Cookeville Police Department believes are more in line with what the penalty should be after sitting in a room by himself reviewing these images that he and many of our detectives across the state are doing. With that, Mr. Chairman and members, I'm happy to answer any questions you might have.
Thank you. Any questions for the sponsor? Seeing none. It is my understanding that this first part of the bill is because of new language that was adopted last year. It's the old language is there. This is adding this into that other section of code. Is that correct?
That is correct. TBI is here if you wanted to ask them more direct questions. They are signed up to testify.
Okay. TBI is here. Does anybody want to hear from them? Or I think Department of Safety is also available for questions if anyone is interested. We're good? Okay. Any objection to the question? Seeing none, we're now voting to send House Bill 2253 on to full judiciary. Everyone voted? Anyone wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, 0 noes, 1 present not voting.
The ayes prevail. House Bill 2253 moves on to full judiciary. Item number 6, House Bill 2491 by Chairman Williams.
Second.
You are recognized.
Members, House Bill 2491 is also a cleanup bill from the District Attorney's General's Office. This bill is needed to address the changes regarding fraud and economic crime fund and the new implementation of the $12.50 public safety fund. It ensures that once this $12.50 fund is enacted, duplicative fees and assessments for fraud and economic crimes are no longer collected in that county. This would simply clean up the bill from last year, ensuring that once the $12.50 fund is enacted, then the fraud and economic crime fund would disappear. So with that, Chairman and members, I'm happy to answer any questions you might have.
Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 2491 on the full judiciary. Everyone voted. Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 2491 moves on to full judiciary.
Thank you, Chairman and members.
We'll go to Representative Salinas.
Thank you, Chairman Doggett. I know I'm out of order here, but I was on the phone with our committee person, Jason Powell. His mom is having surgery this morning, so that's why he can't be here. But I wanted us to take a moment of silence and keep his family in our prayers.
We'll take a moment of silence. Thank you. Next item on the agenda, item number 7, House Bill 1668. Chairman Rudd, you are recognized. No amendments?
No, sir, no amendments.
You may proceed.
Thank you. This is the anti-jugging bill for the Banking Association and for to help our officers fight crime. We have a problem that is spreading across the nation that's now being addressed. Bills are being passed. Tennessee House Bill 1668 is formally designed to combat bank jugging. And that is a predatory crime where suspects that leave financial institutions and ATMs are followed, and at a certain point they are assaulted by the gang or the rings that are preying upon people all across the country now. This is a proactive public safety bill that allows law enforcement and the courts to have more tools in their toolbox to prevent this crime from ever happening when they see them being followed or from a financial institution or ATM. It empowers law enforcement to take action. If they have actual tools, they can be stopped and questioned. If they have tools on them or criminal intent and proof of that is found, that they can prosecute them before the actual crime is committed itself. This is a tiered event. It's a Class A misdemeanor, a Class D felony, a Class B felony. Depends on how severe and how much evidence there is and what they've done. This has been recently passed in Texas on September 1st of 2025, which bill is modeled after. And it has increased the prosecutable power. It is better data tracking for law enforcement, and it also provides arrest and charges for people found and evidence found of their intent. And that's the bill.
Thank you for the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 1668 to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 1668 moves on to full judiciary.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. All right, item number 8, House Bill 1450, Representative Baum. He's not here, so we're going to roll him 2 spaces. Item number 9, House Bill 1454 by Representative Martin. He's not here. We'll roll him 2 spaces. And I'm just going to go out of order and take up the friendly fellow on the back wall there. Item number 17, House Bill 1745 by Representative Freeman. There's no second. Yeah. House Bill 1745 fails for lack of a second. Item 18, House Bill 2301 by Representative Freeman.
Second.
You are recognized. There are no amendments.
I have an untimely filed amendment that makes a small change. I'm happy to discuss it. We can put it on next week, or if the committee would like, we can pick it up now by staying at the will of the committee.
So there's a motion to consider. Is there a second to consider?
Second.
Second. Okay. What is the untimely amendment?
It's drafting code 13622. Is that what you have? Oh, so because it was untimely, do you not have it?
It's not, but I'm not.
Okay. Then I'll just explain what it does. It changes the requirement for, I'll read the exact language. A licensee, it amends subsection E, language of section 2, and substitutes the licensee shall provide a drink, drug, device to a customer for free. And it'll make more sense once we get into it. If you'd like me to describe the bill first, and then we can work through, because it doesn't necessarily change the overall meaning. No.
All right, Leader Lambert.
Mr. Chairman, I'm seeing the legal service folks all talk to one another and to you. Has the amendment, and I was fine considering it if it had been filed with the committee, has the amendment been filed with the committee?
It has not. No, sir.
Okay.
I was under the impression it was. My apologies. I withdraw the amendment, and we'll discuss the bill as it's drafted.
Well, I will say this, Mr. Chairman, well, it's pretty easy to withdraw something that isn't filed yet, but I mean.
Well, the motion.
And Mr. Chairman, I'll have a motion in a few moments if you want to allow the member to potentially describe his bill and how he wants to amend it. I have a potential motion, but I'm going to wait until the member has a chance to at least kind of, if the chairman wants him to at least say what he wants to do with the bill.
Well, he has been recognized on the bill, so if you would like, go ahead
Sure.
and proceed with your explanation.
Sure. Thank you, Chairman and Committee. We are seeing an increasing number of drink spiking in Tennessee. Women don't always feel safe going out to bars and restaurants. No one should ever question whether or not their drink has been tampered with. As many as 1 in 5 instances of sexual assaults are under the presence of some sort of drug-related incapacitation. So this bill takes a two-part approach. One is it strengthens the criminal penalties. In talking to DAs around the state, they were not clear what would happen and what they would charge someone with if someone's drink or if someone had spiked someone's drink and not sexually assaulted them. And so what this does is give 3 different categories of penalty. One, involuntary intoxication is a Class D felony. Bodily injury, if you harm someone, is a Class C felony. And serious bodily injury or death is a Class B felony. And it makes it crystal clear that drink spiking is not a prank. It's not a joke. It's a serious criminal act with serious consequences. The second part is it provides real-time prevention tools. Every year, there are more and more products that come out that test drinks. They're drink testing strips. I know some of the members on the committee were curious what that looked like. They are little pieces of paper that are very inexpensive that you literally dip in a drink and it changes color if there's presence of a drug. This requires bars to have at the ready for anyone that asks a drink spiking test strip. I've talked with the ABC and they feel very confident that they can get rules from the commission that can regulate what these drink strips look like. there are nonprofits all across the state that donate these to people. And again, I think if you have a place where people can feel safe to go, more people will go there, and it'll end up paying for itself. And with that, I stand ready to answer any questions.
Well, you answered one of the questions that I was going to ask you is about these strips or devices or whatever, but do they work on food as well, or is it just purely for drinks?
If the food is liquid based, I would assume so, but it tests, they look like, blood test strip or something. They're small, thin, and you dip them. I can bring one by your office later. They make coasters, and they're all across the board. The important thing is that we're going to rely on the ABC to verify the efficacy of these, and they feel comfortable that that's something they can do.
Thank you. Chairman Russell.
Thank you, Mr. Chairman. And would the bars be mandated to have these strips?
They would.
Yes, sir.
Thank you, Chairman. Yes, sir. They would have to have them, and they don't have to have them out. They would have to have a sign somewhere. They could put it in a bathroom, which is where a lot of the information for sexual assault is currently. They put it inside women's bathrooms, so if they feel that they're in danger, they can go to the bartender and ask for help. And it would just be the same thing. If they feel like someone has tampered with their drink, they could ask the bartender for the strip. They would be responsible for testing it themselves. The bar would not be responsible or held liable for any false readings. It's just giving peace of mind to Tennesseans to be able to know that their drink has not been tampered with.
What would be the penalty for the bar if they did not provide a strip for them?
It's silent to that.
And does it have any penalties if somebody alters somebody's drink, like adds whatever drug to a person's drink?
The first part of the bill does. It increases the penalties for drink spiking. Currently, the weird loophole is that we have people that are getting rape kits taken here in Nashville and across our state. 1 in 5 are under the presence of some sort of drink spiking, and that is a very clear crime. If someone's been sexually assaulted, DAs know exactly what to do. The problem is we have people that think their drink was spiked. They wake up the next morning, they go to the hospital. Hospitals aren't doing a blood work test for that because no crime at that point has been committed or that they understand. And law enforcement is not prosecuting because they don't know exactly whether or not a crime has been committed. This makes it crystal clear that if you spike someone's drink, whether you assault them or not, that is a crime.
What's the difference in this new? First off, would this take this bill create new legislations for us, a new TCA code, or would it add to 3917-107?
It adds to it updates 3917-107.
Okay, thank you.
Yeah, thank you for questions.
Representative Salinas.
Thank you. I really appreciate you bringing this bill because in college, I was in a sorority and we would have to look out for each other or come up with different strategies of how to hold your drink at a bar to make sure, like putting your hand on top of the drink versus holding it at the bottom if it was a like wine glass or any type of glass. And I have had friends whose drinks have been spiked as both female and male. So thank you for the piece of legislation. My question is, how do you envision like proving that someone did it? Because that's kind of tough figuring out who the person is that spiked the drink.
Yeah, that's a great question, and I leave that up to lawyers to figure that out and law enforcement. It is extremely tough, and in many cases, it's almost impossible because somebody will not realize their drink has been spiked for several minutes or 15 minutes later. And by that time, the person that did it is gone and or lurking behind. What this is it just lets those people that are doing it know that if they do get caught, they don't get to go, I was just kidding. It's just a joke. I'm just, playing around. That there is a serious crime and that we cannot prosecute. To the whole committee, I make no illusions that this is going to solve this problem overnight. It's still extremely difficult and challenging to prove, but it gives us additional resources if we can prove it to make sure that these people don't do it again. the likelihood of someone sexual assaulting only one person in their life, if they do it once, they're usually going to have done it multiple times. So this is the precursor. And that maybe that first step. And if we can stop these people, we can maybe stop these future crimes from ever happening. And to your point, this isn't just women. This is happening to men. Maybe not for sexually assaulting people, but stealing wallets. Sometimes it is sexual assault. It's not exclusively a female problem, unfortunately.
Yeah, I mean, I think you're right in the fact that this is not going to help us get every case, but I think having the law present should deter people. And if they can prove who it was, it gives the victim and the people an option of prosecuting. Thank you.
Thank you.
Representative Scarborough.
Thank you, Chairman. I think it's natural for us to get tunnel vision, think about prosecution all the time and what penalties are going to be. What part about this bill that I like, to be quite frank with you, is whenever that person realizes they're having an adverse reaction to something, your test strips is what you're talking about, will allow us to get the proper medical care and try to help identify what the substance was. And that's probably the thing I'm probably focused on more, maybe even more so than the prosecution, because prosecution may be difficult.
I would agree with that. Yes, sir. Thank you.
Thank you. Leader Lambert.
Thank you, Mr. Chairman. In the first part of your bill, I support 100%. You should put these people under the confine of jail. I mean, anybody that's going to spike somebody else's drink, there's no doubt about it. They are up to no good. They are trying to hurt, assault, or do something horrible in that circumstance. It's never funny. It's not a joke. It is always nefarious intent.
Yes, sir.
And so increasing penalties, because it's already a felony to adulterate food. I mean, that's already a crime currently, but increasing penalties on this is always a good idea. The second part of it, I'm afraid is going to backfire because it is endangering the license of a business owner by requiring something in the law. Once we put it in statute saying you have to provide this, if say this is a really successful program, and I hope it is, and all of a sudden they run out of test strips and they give them all out one night, I mean, my concern is going to be they're literally just going to have to shut the place down for the evening because we put something in statute that is a required part of their business. What I would prefer to see, just me, is some sort of a grant program through ABC or some amount of money that's set aside so that we provide these and there's some sort of an encouragement. So this is really a deterrent to business instead of an encouragement or a incentive to provide these test strips. So that would just be me to try to use some sort of enticement to get them to use them while at the same time severely increasing the penalty. I know you had an untimely filed amendment that didn't get filed with the committee. Mr. Chairman, at this time, just to make sure that the member has time to be able to get that amendment together, work with the business community and come back with something that hopefully we could pass, I move that we pass this 3 weeks.
There's a motion to roll 3 weeks. It has been seconded. Any objection? We have one objection. Yeah.
Can I address the motion or what's the posture here?
Go ahead.
Okay. I appreciate that. And in a perfect world, if we had a few more bill slots, this would have been 2 bills. But because we were limited to 10, I decided to combine it. And I appreciate that. And I will talk to others. I've talked to several restaurant owners. They actually think this is a positive for them, that it will allow, their patrons to come in and feel extremely safe, that they know that they are looking out for them. I've worked in the restaurant business, and restaurants all the time have to make sure that they have the product. If restaurant downtown runs out of beer or toilet paper, they're in trouble. And so while I appreciate the concern, this could happen in any place. We require them to have, fire extinguishers. I mean, there are all sorts of requirements that we have for public safety. This is one that I think the time has come for us to take seriously and realize that this is a public safety issue that we can have a meaningful impact on. And while I appreciate the comment that if they run out, I mean, tough, buy more, think ahead. I mean, this is one of those things where I think that we owe it to our folks. I will work with the business community to come up with grants and figure out what they want to do. Yeah, I'll see you guys in 3 weeks.
So there's a motion to roll 3 weeks. We give the sponsor of the bill opportunity to speak on the motion. We'll go back to the sponsor of the motion. for comments if needed.
I'm going to try to say this as circumspect as I can. It disturbs me sometimes when I hear folks from the tourism center of Tennessee saying that they don't care about whether or not a business survives. I've heard that from the Nashville mayor in the last couple of days on taxes. I've now heard it on this bill. I believe there's a way to make sure that patrons are safe and businesses thrive. The bill wasn't ready today. Hopefully in 3 weeks, there will be something that joins these together so that we can combat these heinous actions by these people that are trying to do this and not literally shut down an industry that, quite frankly, is the life's blood of the city you represent. I don't think those two ideas have to live in opposition to one another. So thus my motion.
Okay, the motion before us is to roll House Bill 2301 3 weeks. Those in favor of the motion will say aye.
Aye.
Those opposed? The ayes prevail. House Bill 2301 will be rolled 3 weeks. Let's go to item number 12. House Bill 2153 by Representative Davis. You are recognized. There are no amendments.
Thank you, Mr. Chair, and thank you, committee. And just kind of in speaking with a few members, there are some changes that I would like to make. I would like to make an amendment with this piece of legislation. So if you can either roll me to the heel of the calendar or put me to the next available calendar, I would like to do so. And also, I have a witness that I would like to be able to testify. And so we want to make sure that we were able to get her witness card in on time.
Well, very good. We can roll it 2 weeks. That'll be the next committee meeting.
Thank
So
you, Chairman.
You'll be ready to go then. Without objection, we'll roll House Bill 2153 2 weeks. Let's go to item number 8, House Bill 1450. Representative Baum, you are recognized. There are no amendments.
Thank you, Chairman Doggett. As you all know, if you're arrested for a crime and put in jail, then you can get out of jail while you await trial in one of several different ways. You can post bail yourself, or you can have bail posted on your behalf, either from a family member or a legal guardian or an employer or a professional bail bondsman. There's also a third option, and that would be to have a third party post bail on your behalf. This would be bail by something like a charitable organization. This is a bill that would take that last group, folks who are not family members, legal guardians, employers, professional bail bondsmen, and it would limit how many individuals could be bailed out to 3 individuals per calendar year, and 1 individual could not be bailed out more than once in a particular calendar year. The motivation for this bill would be to promote safety in our communities, and that's because statistics show that when individuals are bailed out by these third-party groups like charitable bail organizations, they are less likely to reappear in court when they're supposed to, and they're more likely to commit crimes while out. And maybe it shouldn't be a surprise that that is the case. The reason is because these third-party entities are not licensed, and so they face no oversight by the state. They have no liability if the individual fails to appear in court, and so there's no consequences. And this is partly because these charitable bail organizations don't have the power to arrest an individual who fails to appear in court. They don't have some of the mechanisms that a professional bail bondsman would have in order to ensure appearance in court. And so this is a bill that would be designed to promote safety by limiting what these third-party entities are able to do in terms of getting folks out of jail.
Thank you for the explanation. Any questions, Representative Salinas?
Can you cite what study you looked at for for the numbers you gave on those third-party charities?
Yes, there's actually a number of different studies that have examined this over time, but probably one of the most recent ones that gives some of the best evidence is a study by CNN. It's through their investigative arm called CNN Investigates, where they looked at some of these statistics in 3 different areas: in Indiana, in Minnesota, and in Seattle. And I'll give you some of the statistics that they report. They said if they consider individuals who have been arrested and then later convicted, folks who were bailed out by the Minnesota Freedom Fund were essentially twice as likely to fail to appear in court at a rate of 42% compared to 22.5%. And then another statistic, this one's out of Seattle, the Northwest Community Bail Group there had a failure to appear rate of 52% versus 24% for folks who were out on bail in one of these other through one of these other means. And so the failure to appear rate seems to be about twice as high. CNN also looked at the number of individuals out on bail through one of these third-party entities that had committed crimes, and they found that there were a number of individuals out on bail who had committed murder. And the study did a case study of 9 of them, and in their study, they actually list the individuals' names and the states that they're in with a little profile on exactly what the murder involved. And so the statistics do show that there's an increase in failure to appear back in court and an increase in the number of crimes that are committed while out on bail.
Okay, so CNN is not a research institution. When we statistics, its sample size, all of those mean something. And CNN is not a reliable source when it comes to talking about populations or trends or statistics for that matter, especially because we don't know the sample size, no, we know their methodologies. I thought you were probably going to cite a journal that works on this, or a university, or any other. Do you have any other studies that have the academic rigor that what you are asserting deserves, really? Because you can't use statistics if you haven't used citing your methods and citing a sample size.
Yes, there are other studies. I thought you would like CNN, so I gave that one. Other sources include statistics from the Department of Justice through their Bureau of Justice Statistics. And then in terms of journal articles, actually some economists have published studies on this. One is by Eric Helland and other co-authors in the Journal of Labor Economics, which is published out of the University of Chicago. They have some statistics as well.
And what were their findings?
Their findings,
Specific to that.
okay, looking at the article in the Journal of Labor Economics, they found that individuals who had been bailed out by a professional bail bondsman were 58% less likely to remain at large and 28% less likely to fail to appear in court than individuals who are out by one of these other means.
Okay, well, I'll have to look that up to confirm.
Thank you. Any other questions for our sponsor? Seeing none. Any objection to the question? Seeing none. We're voting to send House Bill 1450 on to full judiciary. Everyone voted. Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. House Bill 1450 moves on to full judiciary.
Thank you all.
Yes, sir. Thank you. Item number 9, House Bill 1454 by Representative Martin.
Second.
You are recognized. There are no amendments.
Thank you, Mr. Chairman and committee. Leader Lamberth passed language in the 113th General Assembly which authorized the death penalty for convicted child rapist. Hamilton County's district attorney, who's here today, Cody Womp, has since brought several of these cases to trial. And she sought the death penalty, but realized that the current list of aggravating circumstances was inadequate to sentence these and future defendants to death. This bill updates the list of aggravating circumstances to fit the horrific crime conviction of a rape of a child. Section 1 adds a dozen aggravating circumstances to Tennessee Code, and in order to sentence a convicted criminal to death, one of these aggravating circumstances must be proven by the state. I want to thank District Attorney Wamp and her team for their commitment to safety and the rule of law. And Mr. Chairman, we have a couple of people here, if it's permissible, that would like to speak on this. The Executive Director of the Tennessee District Attorney General's Conference, Stephen Crump, and also our Hamilton County District Attorney, Cody Wamp. And with that, I stand ready for questions, but I'm also would ask that we give them the privilege of speaking.
Thank you for your explanation. Are there questions for the sponsor? We've got two on the list that want to speak. All righty, we will go without objection. We're going out of session. We have here Cody Wamp and Steve Crump. If you will introduce yourselves for the record, you will each have 3 minutes for comments, and then we will open it up for questions.
Whew, 3 minutes is not a lot. My name is Cody Wamp. I'm the Hamilton County District Attorney, the 11th Judicial District. I'm excited to be here this morning. Thank you, Mr. Chairman, and thank you, Leader Lamberth. To put it very simply, we had the most horrific aggravated child rape case that occurred last January in 2025 in Hamilton County that I've ever seen in my 12-year career. It was a father who raped both his 1-year-old child and his 4-year-old child. We have video evidence of both of those offenses. It was at that time that I told my staff we will be seeking death because thankful to you all, death is authorized under the rape of a child and aggravated rape of a child statute. We then, as an office, began to look at the aggravating factors, one of which would be required to actually seek death and receive from a jury the punishment of death. We realized that those aggravating factors had not been updated with that death penalty legislation that Leader Lamberth was responsible for, and there was no factor that applied to the most egregious case of child rape, but really only 1 or 2 that would ever even apply to child rape. They all apply, with the exception of one or two, to murder. So what needed to happen was we needed to add aggravating factors to reflect the allowance of death that you all were responsible for in those rape of a child statutes. We've done that with legal services. We recommended as an office even more than 12, but we narrowed it down to 12 aggravating factors that we could present one or more of to a jury in a rape of a child trial, so that that jury would have the ammunition to punish our worst offenders to death. That is what this does. I was excited to be over here today because it was a case in Hamilton County that sparked this change in the legislation. And I'll be here any time it's set before any committee because I feel strongly about it.
Thank you.
Thank you, Mr. Chairman and Committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. I will just echo the comments that General Wamp made. This is a bill that was adopted by the conference as one of our legislative package. We are certainly pleased to support it. And with that, I'll save 2 minutes and 45 seconds and give it back to y'all.
You actually saved 2 minutes and 46 seconds. So thank you. All right. Any questions for our guest? Thank you both for being here.
Thank you, sir.
We'll go back into session. Any questions for the sponsor? Leader Lambert.
Thank you, Mr. Chairman, and thank you for taking the next step in what is an important way to both deter and punish some of the most heinous crimes that anybody could ever possibly imagine. And I appreciate the General's testimony. I appreciate your District Attorney General and General Wamp and General Crump and everything that they do within the conference. We went as far as folks were comfortable going in the aggravating factors last year. This adds some additional aggravating factors that hopefully will continue to hold these folks accountable to the ultimate penalty that the law can provide. So thank you for stepping forward and being bold and bringing a bill of this nature forward. It's obviously a very grave thing anytime we are talking about the execution of a Tennessean, but when you rape a child, that is exactly what should occur. You have forfeited your own life. So thank you for bringing the bill.
Any other questions, comments? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1454 on to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 0 noes, 1 present not voting.
The ayes prevail. House Bill 1454 moves on to full judiciary.
Thank you, Chairman and Committee.
Item number 11, House Bill 1449 by Representative Gillespie. You are recognized.
Thank you, Mr. Chairman and Committee. This bill, 1449, is based off of a statewide task force 2 years ago on the issue of drag racing that was convened, that this body passed. And really what we're changing are two things. We're changing the definition of what drag racing actually is. And then we're also allowing for reckless driving to be captured in that. And then we're also allowing or requiring the officer, similar to what we do with the DUI, requiring an arrest to take place and the seizure of that vehicle until that conviction takes place. And with that, I welcome any questions.
Thank you. Leader Lambert.
Thank you, Mr. Chairman. And we had talked out in the hallway. Look, good bill, good update to the definition. I personally don't understand why we would call something street drag racing that happens on streets. It happens in alleyways. It happens in parking lots. It happens, unfortunately, in a lot of variety of areas. And you're expanding that definition. I don't have a suggestion for today's purposes. It's a good bill. But between sub and full, and members, I may ask legal to draft up an amendment that just leaves it as drag racing with an enhanced definition. Because I am concerned that at some juncture, a jury down the road is liable to look at the charge that someone's charged, street drag racing, and the proof in front of them that it happened in a parking lot or somewhere. And it just adds some, I guess, it adds a wrinkle into it that's not necessary if we're just updating the statute. So just a comment. And again, for today's purposes, Mr. Chairman, I mean, it seems to be a good bill in my opinion, but it just, I was a little uncomfortable with the language of how we're updating the label that you put it on this particular crime.
Thank you, Mr. Chairman. And Leader, I agree with you. I am going to go look back at the minutes, the reports, just to see why the DAs were recommending that very specific change. There may not be a reason, and we just did it, but I would love to work with you all on that.
Well, Mr. Chairman, we could have asked him, but after the last bill, they just left. So maybe you can ask him, I guess, between now and next week.
Any other questions for the sponsor? Any objection to the question? We're now voting to send House Bill 1449 on to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. House Bill 1449 moves on to full
Thank you.
judiciary. Item number 13, House Bill 2284 by Representative Butler. You are recognized. There's Amendment Code 12956. Do you wish to proceed with that amendment?
Yes, Mr. Chairman.
You are recognized on the amendment.
Thank you, Mr. Chairman. So whether you know it or not, I represent a very rural district, and this problem has arisen on multiple occasions where we have property owners that are having their fence cut and side-by-sides specifically or other motorized vehicles are crossing their property illegally. And I'm sure everybody in here, if you have a fence around your property in front of your house and somebody cuts your fence, you're not going to be very happy. Well, that's what's happening to our farmers in these rural areas. And the side-by-side business is good business. It does create revenue, but it also comes with some challenges. And this bill seeks to address some of those challenges. So if you cut somebody's fence to trespass on their property with a motorized vehicle, this legislation would specifically require a $2,500 fine, no jail time, restitution for the damage you've done to the property on the first offense. The second offense, you would be required to pay restitution, the $2,500 fine, and they would repossess the vehicle. And that, Mr. Chairman, is the explanation of the bill, or the amendment, I should say. And with that, I'll be glad to answer any questions.
The amendment makes the bill?
Yes, sir, Mr. Chairman.
Any questions on the amendment? Chairman Russell.
Thank you, Mr. Chairman. To the sponsor, did you say repossess the vehicle or seize the vehicle?
Thank you, Mr. Chairman. Seize the vehicle. Thank you for that correction.
Thank you.
Any other questions on the amendment? Seeing none, any objection to the question, we're voting to adopt Amendment Code 12956 on the House Bill 2284. Those in favor will say aye. Those opposed? Ayes prevail. You adopt your bill as amended. Any questions for the sponsor on the bill as amended? I do have a question. This seizure, what type of seizure is this of the vehicle?
Thank you, Mr. Chairman. It's a criminal seizure.
It's criminal. Okay. Any questions? Leader Lambert.
Just a statement, and I mentioned the sponsor just a moment ago. It is in the Senate Delay Bills Committee. So, I mean, I realize that's not always something we are concerned with here, but it would be impossible for this bill to move all the way through on both chambers unless for some reason it is able to be rescued out of that committee on that side. So other chambers issue, but I did at least want to mention it.
Very good. Any other questions? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2284 as amended on the full judiciary. Has everyone voted? Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. House Bill 2284 as amended moves on to full judiciary.
Thank you, Committee and Chairman.
Item 14, House Bill 1519 by Representative McCalman. You are recognized. There are no amendments. Please proceed.
Thank you, Mr. Chairman, and good morning, members. What this bill does is enact the SHARE Act, which stands for Safe Highways and Roads Enforcement. What it does is add a state penalty onto moving violations issued anywhere in the state, which will be allocated for our road highway fund. And with that, I stand ready for any questions.
Questions for the sponsor? Chair Lady Littleton.
Thank you, Mr. Chairman. Would this just be for state violations or for city as well?
Thank you, Mr. Chairman. Chair Lady Littleton, this would be for any moving violation issued in any jurisdiction in the state.
Thank you.
Chairman Russell.
Thank you, Mr. Chairman. And does this include court costs, or does it go above and beyond what court costs are?
This would be in addition to, currently all the penalty revenue is city and county, pays for the courts, pays for the jails. This would be a state penalty that would be collected by the court and remitted, just like they would do with any revenue that goes back to the state.
Thank you.
Could you tell us what the driving offenses, the moving violations would be?
Yes, Mr. Chairman. So speeding tickets, hand-free violations, DUIs, violations of that nature, sir.
Thank you. Any other questions for the sponsor? Any objection to the question? We're now voting to send House Bill 1519 on to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 1519 moves on to full judiciary.
Thank you, Chairman and Committee.
Item 15, House Bill 1769 by Representative Clemens. He's not in the room. We're going to roll him to the hill without objection. Item number 19, House Bill 2229 by Representative Dixie. Without objection, roll 3 weeks. Item 20, House Bill 2232 by Representative Dixie. Without objection, roll 3 weeks. Item 21, House Bill 1441 by Representative Brooks. She is not in the room. We are going to roll 2 spaces without objection. Item 22, House Bill 1814 by Chairman Russell. Are you ready to proceed?
Thank you, Mr. Chairman. I believe that's the one we was going to roll to the hill.
Okay. We will roll to the hill without objection. We're running out of hills here. Let's try this one. Item 23, House Bill 1871.
Motion.
Representative Ashley.
Chairman, this bill requires that anyone convicted of second-degree murder is sentenced as a range 2 offender at a minimum, regardless of the other sentencing provisions. This bill strengthens the sentencing for one of the most serious violent crimes under Tennessee law. It ensures that anyone of second-degree murder is sentenced as a range 2 offender at a minimum, regardless of other sentencing provisions. Second-degree murder is a Class A felony, and a range 2 offender convicted of a Class A felony is sentenced between 24 and 40 years. Further, since second-degree murder is a Class A felony, it is also included in the 2022 Truth in Sentencing legislation, which requires 100% service of sentence imposed. Right now, sentencing rules of Title 40 can allow room for downward range that do not allow or do not always reflect the gravity of this offense. The purpose, this bill closes the gap by making clear that the range 2 is the floor, not the ceiling. Judges will still retain discretion to impose a range 3 sentence when appropriate, based on the facts of the case and the defendant's conduct. The goal is accountability and consistency. Violent offenses of this nature should not result in sentences that fall below what Tennesseans reasonably expect for such serious harm. This bill sends a clear message. Tennessee takes violent crime seriously. Victims deserve sentences that reflect the severity of the offense, and our sentencing structure should not allow outcomes that undermine public confidence in the judicial system. With that, I stand for any questions.
Thank you for that lengthy description. We do have individuals here that wish to testify on this.
We have the people from the DAs.
Yeah, okay. Without objection, we'll go out of session. We've got Steve Crump, Courtney Lynch, and Brittany Lavelle here on our list. If you will introduce yourself for the record, you'll have 3 minutes for comments.
Thank you, Mr. Chairman and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. The bill before you currently is part of our legislative package this year, and its purpose is very simple. There are two offenses where an intentional action, one that is directed at a specific outcome, results in the death of another human being. That is first-degree intentional premeditated murder or felony murder, and second-degree knowing homicide. We believe that if you look at our sentencing code, that the 15 to 25 afforded by a Class A felony does not match what the severity of this crime is. And as such, we would ask that this committee pass along and stand for the fact that when somebody is murdered, it doesn't go away in 15 years or going to go away in 100 years. So with that, I'll stand ready for any questions.
Thank you for that. Any questions for our guest? Seeing none. Thank you for being
Mr.
with
Chairman.
us. We'll go back into session. Representative Ashley, you're recognized.
I'd move for passage.
Very good. Any questions for the sponsor? All right. Any objection to the question? Seeing none, we're voting to send House Bill 1871 to full judiciary. Has everyone voted? Anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 0 noes, 1 present not voting.
The ayes prevail. House Bill 1871 moves on to full judiciary. Brings us back to item 21, House Bill 1441 by Representative Brooks. We just got an email before I called you up. You're wishing to roll this 2 weeks? Without objection, roll 2 weeks. Brings us to item 24, House Joint Resolution 840. Representative Jones, Leader Lambert, you recognized.
Move this item to last calendar 2.
There's a motion and a second. Any objection? There is objection. We're now voting on the The motion to roll to last calendar 2 for House Joint Resolution 840. All those in favor say aye.
Aye.
Those oppose? The ayes prevail. House Joint Resolution 840 be rolled to final calendar number 2. Brings us back to item number 4, 1802 by Representative Capley. He is not here. We will roll back to the Hill. We get someone to get in touch with him. Let's go to Representative. Item 15, House Bill 1769 by Representative Clemens. He's not here. Members, we're going to take a 5-minute recess without objection. All right, members, we're going back in session. Item number 4, House Bill 1802 by Representative Capley will be rolled. Without objection, it's going to be rolled 2 weeks. See, we made contact with Representative Clemens on House Bill 1769, which is item number 15. Without objection, be rolled 2 weeks. Brings us back to item 22, House Bill 1814 by Chairman Russell, and he wishes to roll.
Next available calendar,
Next
which if my
available-
math is correct, that'll be 2 weeks.
Yes, roll 2 weeks. I believe that is a completed calendar that we have here. This is 2 weeks in a row. Don't get too excited. It's probably going to slow down in the next few weeks. But any other matters before this committee before we adjourn today? Leader Lambert.
Mr. Chairman, only that we as a committee are proud of you, sir, for manning the ship and guiding us well, because with 15 minutes left in this committee, you have completed the entire calendar. And I don't know a lot of other subcommittees out there that are doing that this time of year. So I appreciate everybody being here for it. You've seen definitely an economic and efficient gavel being swung. Thank you, Mr. Chairman.
Well, thank you. We have a very efficient and effective committee, I will say. Chair Lady.
Thank you, Mr. Chairman. I know I'm out of order, but we have some Convention of State people here. And Ramona, and I'm going to mess up her last name, so I'm going to leave it at Ramona. That's from Cheatham County. So let's just give them a nice little welcome, please.
Yes, thank y'all for being with us today. Anyone else?
Second.
All right. Without objection, we are going to adjourn. See you in a couple weeks.